Okay, welcome everyone to another random walk down Mill Street. This week's topic is, I titled it Unearthing a Halakhic Controversy, Case of Cohen versus Congregation Shearith Israel. Just by raise of hands or a thumbs up or something, has anyone heard of the case Cohen versus Shearith Israel? Not even the law professor. Okay. Excellent. So this story, it's going to be a little bit involved. I'm going to try to keep it moving. It's about a law case, a court case, which had several iterations and appeals, which had to do with the disinterment of a body from Shearith Israel Cemetery and reinterring it somewhere else. Now, Shearith Israel has long history of such issues, going back to the early 19th century, and most notably when the Bowery was extended to what would become St. James Place, the Chatham Square Cemetery had to be cut basically in half, and more than 200 bodies disinterred and reinterred in 21st Street. There and incidents earlier than that, going back to the 18th century, where it was pretty established, according to Halakha and according to the responsum that Shearith Israel received from the Beit Din in London back in the 1790s, that the prevailing halakha is you can not allowed to disinter a body once it's been buried, except for a few specific exceptions. And so we're going to get into this case shortly, or right now. Why not? Let's start. Let's start with my sharing my screen here. Okay, unearthing a halakhic controversy, the case of Cohen versus Shearith Israel. I'm trying to make this screen a little bit smaller. Okay. So here we have the citations, and if anyone wants it, I can email it to you. The case begins in 1903, or the first decision from the appellate division starts earlier, and then there's a subsequent cases that also go to the appeals court and get decided going all the way to 1906, and the end result happens in 1907. But here are the facts, the basic facts. Adela Cohen died in 1890, and she was buried in Shearith Israel Cemetery. Her husband, Daniel Satius Cohen, died in 1901. Rather than bury him next to Adela in Shearith Israel Cemetery, the family purchased a family plot in Mount Nebo Cemetery, which is nearby, and interred him there. Then they sought to disinter the remains of Adela Cohen and reinter her next to her husband in Mount Nebo Cemetery. Shearith Israel objected to this, maintaining that this type of disinterment is contrary to halakha. And since Shearith Israel was the owner of the cemetery plot, they disallowed the family's request. The family then applies to the court to permit them to disinter the body, and permission was granted to disinter her. But on appeal, the court ruled in favor of Shearith Israel for technical reasons, that the statute upon which the Cohen family had brought their case did not apply to religious cemeteries. And in its decision, it says, it seems to me, this is the judge from the original 1903 case, it seems to me that the special term was without power, that's the court, without power to make the order appealed from, and on this ground is our duty to reverse it. But then he had something very important. In thus deciding, I do not express any opinion on the question whether, under the general law of the state, as to the right to control the disposition of dead bodies, the petitioner, the Cohen family, might not be able to obtain relief in an equitable action instituted for that purpose. So the judge is telling them what to do. Don't sue under this statute, which doesn't apply to Shearith Israel, you have a different route to get equitable relief, which basically means fairness. And so that's exactly what happens. And here we have, I think I went too far. Okay. To get a sense of who we're talking about, this is a simplified family tree. The woman who died in 1890 is Adela Cohen, Adela Isaacs Cohen. She is a descendant of one of Shearith Israel's oldest families, a family that was in New York in the 1730s or 20s, and also in Newport. Actually, it came to New York in 1697. This is one of the earliest families in Shearith Israel's history. She's a direct descendant of Abraham Isaacs. Her name is Adela Isaacs. And she marries Daniel Seixas Cohen, who is a descendant of two different families, the Cohen family, also a colonial era, and the Seixas family. In fact, she's a direct descendant of Benjamin Mendes Seixas, who was a veteran of the American Revolution, signer of the Buttonwood Agreement. We decorate his grave in Chatham Square every year at Memorial Day. So what I'm showing you here is that these are, they have pedigree, and they have a long history with Shearith Israel. And so what happens is Adela is buried. Daniel Cohen survives later, and the family decides to purchase a family plot in Mount Nebo. We'll see why in a moment. So after receiving the loss, the Cohen family is undeterred, and they continue. And so this is the decision. This is the final decision. This is a little excerpt of it, which I want to read to you and talk about with you. Not that long. I have and we'll go through it hopefully a little quickly, but it's important to get some of the background information. So Adela Cohen died on the 28th of February, 1890. She was buried in the row in Defendant's Cemetery at Cypress Hills, which means that she was not in a family plot. She was just the next row. There are two types of burials in our cemetery. There's row burial, where you get the next available grave, or you are part of a family plot. Your family has paid for 6, 8, 12 graves in a row, and that's a family plot. And that becomes important for what the family's wishes are. So she's buried in this row grave in 1890. The next space next to her, as we do today, is reserved for her surviving spouse, for her husband, Daniel. And he died in 1901. And here, listen to this. Adela Cohen, during her life, expressed to Daniel and their children her regret that they did not possess a family plot in which they could all be buried. And subsequent to her death, Daniel expressed a wish, that's her husband, that the whole family, including Adela, should be buried together. And he requested that his children should obtain a plot, if possible, for that purpose. Now, why didn't he do it himself? Well, he was unemployed and sickly and couldn't afford it, basically. That's really, the family could not afford a family plot. And that is the only reason why. In fact, some of the testimony in the case was that this woman, Adela, had tried to use some of her cousins' family plots, but was not allowed by those surviving cousins to do so. And so anyway, 2 days before his death, this is the husband, 1901. And while he was very ill, his son Howard purchased a plot in Mount Nebo Cemetery, short distance from Shearith Israel. And the plaintiff, that's the Cohen family, caused his remains, Daniel Seixas Cohen's remains, to be interred in that plot. So when the husband dies, he goes to a different cemetery. About the time that this plot was purchased, but before the death of Daniel, application was made to the defendant at Shearith Israel, so he's still alive. They say, we want to take out Adela, our mother, and put her in this family plot that we just bought in Mount Nebo, but was refused to them on the ground that such disinterment was forbidden. Subsequently, this action was brought to procure judgment, establishing the right of the family to disinter the remains of their mother and put her in the family plot in Mount Nebo Cemetery. The issues raised by the pleadings were sent to a referee to hear and determine, And upon his report, the plaintiffs, the family, had a judgment in their favor that they could disinter Adela and move her out of the Shearith Israel cemetery, from which the defendant, Shearith Israel, appeals. So I hope you get the basic idea. Shearith Israel lost according to the referee's decision, and they're appealing it. And now here comes the appeal decision. Much evidence was given at trial bearing upon the question as to whether it was permissible to disinter the remains under Jewish law. So they're asking about what's the halakha. That of the plaintiffs tending to show that it was, and that of the defendant that it was not permitted to move her. The referee reached the conclusion that the contention of the plaintiffs was correct, that the family was right and they could move her. And it's difficult to see how he could have ruled otherwise based on his finding. In an elaborate and interesting opinion, this is the referee's opinion, he fully sets forth the reasons which led him to conclude as he did, and which we would adopt were it not for the fact that the subjects are discussed, which do not seem to be necessary for a disposition of the question presented. Meaning, this judge thinks that the referee did a great job, even more than is needed to get to the answer that he did. Having found, the referee, having found as a matter of fact, that's his job, he's the fact finder, that there was an expressed intent of the family or that the body of their mother should be removed, entitled them to remove it later, under the practice adopted by the defendant corporation, under the practice of Shearith Israel. Meaning, according to what the judge is saying, because the family had the intent to use a family plot, even though they didn't have one at the time that the mother died, they wanted one, that is enough to permit them to move it. And that at the time that Adela's, the wife of the woman was buried, her husband had this intent. This is a matter. This is that they're finding fact that the husband said he had the intent to remove his wife to a family plot, and that was all that's necessary to entitle the plaintiffs when applying to a court of equity for the relief that they wanted to be able to move her. And now this is really important. This line, the finding that he had this intent, and that Adela had prior to her death expressed a wish that all of the family should be buried in one plot, and the unanimous feeling of the children to the same effect, coupled with the purchase of another lot and the request made of the defendant, Shearith Israel, before the death of Daniel, we think would have justified a finding that the interment of Adela was conditional. We'll understand why that is an important word later on, meaning when she was buried in Shearith Israel, that wasn't the final resting place of her, and therefore the disinterment was not contrary to Jewish law. This is an appeals court as a matter of law saying that what they did was halachically permitted. Okay, today we would never have cases that ruled like this. We would never have a case that went into the halachot or that decided to rule on what was the proper halakha. The cemetery of Shearith Israel is maintained pursuant to the authorities of the state of New York, and the absence of any regulation, meaning Shearith Israel doesn't have any rule that says who is permitted the right of removal. All of this stuff is really this is all very shaky. And that there was no agreement between the family and Shearith Israel as to what they were permitted to do or not permitted to do. That is, so they're equitable grounds. That's this case finding under equitable grounds rather than Jewish law. He sort of throws this in afterward. After he said that he's finding according to Jewish law, he says, well, you don't even need to get to Jewish law to get to my decision. Ecclesiastical law is not a part of this law of the state, nor are equitable rights to be determined by it. So he saves himself a little bit and says, it's not, I'm not ruling on the halakha, or the fact that I think that the halakha should be one way is not what makes this the decision that should be followed. And then he says it could be that if there was an agreement that the cemetery made with the family to follow X, Y, and Z interpretation of halakha, okay, that wasn't the case here. So that's the appellate decision upholding the finding of the referee that it was permitted for the family to disinter the remains of their mother and move her to Mount Nebo Cemetery, while Shearith Israel, basically, it's a bad loss for them. They fought for years saying you're not allowed, it's against halakha to remove someone from our cemetery. This does not follow any of the real exceptions that are in the halakha, as we'll see later. And they lost. Now, what's really interesting, so I'll just show you, we're not going to spend any time on this page, but this is just to show you, these are like law textbooks or annotated laws, which show you which cases apply to what statutes. And so this case, Cohen versus Shearith Israel, is good law and has been for a while and is used in a lot of different things. We don't have to get through it, but basically it's saying that it wasn't a one-off, that this case was cited and is cited as recently as 2009. This case has been cited, Cohen versus Congregation Shearith Israel, as having maybe not all parts of it, but as being good law. And last year, in a law review article, this case was talked about, and specifically to this very pressing issue that's not my concern, but just so you should be aware, that the First Amendment, prohibits the mixture of church and state, and so courts, without getting into all the legal reasons for it, we can ask Professor Schwarzschild about that later, the Establishment Clause, but courts avoid making any determination of religious law. They completely avoid it. And Professor Helfand in his article says that's a modern thing, that in the 20th century, as we see in our case, courts made decisions about religious law, using religious law, even though today they would never do that. And he has his own conclusions to make about what's right or not. But just showing you that this case is still talked about, still cited, even today, even though it's back from 1906. So now I want to show you how absolutely extraordinary the decision of the referee is. The judge was absolutely right. This is an amazing decision. Whether it's the correct one, I don't know, but it is totally amazing. The referee's name was Edward B. Whitney, not a Jewish person. He was a lawyer and later a judge. And you can see he was a pretty senior person by the time he was not a judge. He was a lawyer when at the time he heard the case as a referee, and then he became a judge of the Supreme Court in 1909, I think, shortly after. Anyway, I want to read this to you because I think it's so. This is what attracted me. This is from the record of the appeal. So that not just the decision, but all the evidence that came into the appellate court to determine. So this is from the decision of the referee, just a part of it. The greater part of the record of the original case is taken up with expert evidence upon the questions of Jewish law thus raised. It is conceded by both parties that, as a general rule, disinterment is prohibited. Halakha says you can't take some, once they're buried, you can't take them out of the ground. In order to allow it, the case must be brought within one of certain established exceptions. Okay. Defendant denies, meaning Shearith Israel says there is no exception, they can't be disinterred. Plaintiff says there is an exception and they can disinter. A very strong array of witnesses has been produced on behalf of the defendant. Shearith Israel brought in a lot of witnesses, expert witnesses. Those examined at the trial were Dr. Solomon Schechter, president of the faculty of the JTS, former reader in rabbinics at Cambridge University, professor of Hebrew at University College London, Dr. Louis Ginsberg, professor of Talmud and rabbinics, Dr. Bernard Drachman, reader of rabbinical codes at the seminary, Dr. Henry Pereira Mendes, defendant's minister, Shearith Israel's rabbi for the past 27 years, Reverend Mildola de Sola, rabbi of the Spanish-Portuguese synagogue in Montreal. And if that wasn't enough, there were accepted into the record by stipulation affidavits from Chief Rabbi of the British Empire, Herman Adler, Chief Rabbi of the Spanish-Portuguese Jews Congregation, Moses Gaster. That's on Shearith Israel's side. For the plaintiffs, for the Cohen family, they had Dr. Kaufman Kohler, president of Hebrew Union College. They had Frederick de Sola Mendes, rabbi of Shari Tefillah, and brother of Henry Pereira Mendes, and some others, Rabbi Samuel Sale, a reformer. And then what's really interesting, as they say it here, is J.D. Eisenstein. I don't know if how many of you have heard of J.D. Eisenstein, but he was an Orthodox scholar at this time, living on the Lower East Side, who wrote articles for the Jewish Encyclopedia. He comes in on the side of the Cohen family with all these reform rabbis. Interesting, right? This is what caught my eye. Okay, huge names in Jewish history and Jewish academics and Jewish scholarship being brought here in this case to decide Jewish law in the courts of New York State Supreme Court. And here is the continuing with that decision from the referee. The main point, this is the decision that is published, you know. The main point at issue is the proper construction of the words bitoch shelo. This is from the decision of the referee, a goy. Okay. As used in connection to the works of rabbinical law. The first authoritative statement upon the law of disinterment is in Smachot. This book belongs to the 2nd century. And then he goes on. I mean, can you imagine? The Talmud was codified about this time, and Shulchan Aruch, I mean, it's incredible. And then he has a quote from Yoredea. It's not permitted to remove the dead and the bones from a respectable grave. And here becomes the important things. You can't remove anybody for anything except bitoch shelo. It is permitted even from a respectable grave to a disrespectful grave, because a person should rest with his forefathers, with his fathers. And the meaning of the words bitoch shelo are at issue in this case. So we'll talk about that later. And then continuing, it says, other reasons that you could move somebody is to move into the Holy Land, or if their grave is in danger of being damaged. And here's the key words again for the other issue that comes up. If the body was placed there al minat lifnoto, with the intention of moving. Those are the two issues that are at play. Whether moving it to a family plot in another cemetery is bitoch shelo, and whether there was an intention at the time of burial to move the deceased. Okay? And here's the finding. Since the question thus arose, it has been argued by the generality of the Orthodox camp that bitoch shelo refers to the place of burial and its ownership during the life of the deceased. Meaning, if you have a person who has a family plot, but for whatever reason they're buried, let's say they have a family plot in Pittsburgh, and that's where they own a family plot, but they pass away in Cleveland, and the people in Cleveland bury him right away. The family can disinter him later and put him in the family plot in another city. That's bitoch shelo. It's permitted to move him under all circumstances if it's to go to his own property, his own burial place. And so the meaning of those words is argued in halakha, and whether it refers to property that was owned or somewhere where the family is buried. And we don't have to get into the details there, but they get into it in this case, really, really nitty gritty. But then he says, so if I were to find that when the wife was buried, her husband just said, yeah, okay, let's bury her in Shearith Israel Cemetery in the place where she should be, I would come to the conclusion with all the weight of the evidence as to the Orthodox scholars that they can't remove her in this case. But then he says, there is another difficulty. Was the interment of Adela Cohen conditional or unconditional? This is a vital question in the case because the third exception above in Yoredea, I mean, this is a Gentile referee talking about Yoredea and the halachot. I mean, I can't, it's so shocking. He's saying, was it al tanai or was it not al tanai? Was there an expectation to move her later or not at the time that she was buried? And that is the deciding factor in this case that they're going to talk about. That's going to be controlling. And here comes toward the end, how he decides, the referee, after pages of halakhic analysis. There is no presumption that Daniel Cohen, the husband, stated or had a conditional intent. He did not say to the Shearith Israel, or even had in his mind, that his wife should be moved later to a family plot. At least there's no presumption. So you didn't find a fact. There's no presumption of what I would find as the exception allowed in the Yoreh Deah. He only wished for a future removal of the body. He did not look forward to it as a certainty. I do not feel that I have sufficient evidence to base an affirmative finding of fact as to whether or not he communicated that intent to any witness. The case, therefore, narrows down, as I view it, to the one question: what presumption should the court of equity adopt in the absence of sufficient evidence either way? Now, this is very tricky legally, which I'm not going to get into, but in what we saw earlier made it sound like the referee had a finding of fact that there was an intent to disinter her at the time she was buried. And here he's expressly saying, I don't make that finding of fact. I'm only leaning on the presumption of what a court of equity should do in this case, which might, anyway, we'll leave it at that. And then he has a couple paragraphs which are completely confusing, but basically he says there's a presumption that burials in Shearith Israel Cemetery generally, usually, are conditional, and we should presume that Adela Cohen's is. And this is really weak, by the way, but that's what he finds. Then he says at the end of this, that because this is what he thinks is the controlling presumption, that there was a presumption that this was a conditional burial, which means I'm burying her on the condition that I'll move her later to the family plot that we don't have yet, that we don't own, that they should find for the family, and it's permitted to move her. And that's the referee's finding, which is upheld. It's really pretty weak at the end. The decision is pretty weak, but it gets upheld. And that's the way it goes. And in 1907, Shearith Israel, there are markings in the book, disinterred her, and she got moved to Mount Nebo, which is presumably where she is today, with the rest of her family. So here is the actual Shulchan Aruch. There's other sources we could bring, but just to show you that these two issues come right out of the Shulchan Aruch. You're not allowed to move a dead body or bones from a grave, regardless of whether it's to move it to a nicer place or not. You just can't do it, except ubetoch shelo. If it's this phrase, which is at a question, into his own, then it's permitted no matter what. In all cases, it's permitted to go to his own burial plot. That was one issue that they had to discuss. And then the next one I bolded here, if it was with the intention to be moved later, also okay to do so in all cases. Those are the two issues that the court had to decide on. Al pi halakha. So we're gonna go through what without a whole lot of analysis. So let's see what the comments here are. Edgar Nathan is representing Shearith Israel. I don't think Eisenstein is related to the Kaplan family. That's a different Eisenstein. That's Judith Eisenstein. That's, I think, Kaplan's daughter. That's a much later period. This is from an earlier period. Mordechai Kaplan is alive here, but I don't think his daughter is, or just being born around then. So J.D. Eisen. We'll get to who he is in a little bit. Henry Paramendes. This is from his testimony, taken right out of the trial record, which is available online. If anybody wants, I'll send you the link. You can get this record available. And here's a picture of him. Let me make this smaller so you can see the pictures. It is not permissible under Jewish law to disinter the remains of Adela Cohen, which were interred in Shearith Israel Cemetery in 1890, unconditionally, meaning it was just a regular burial for the purpose of reinterring her in another cemetery. Not permitted, according to Halakha. I can cite authorities in support of my construction of Jewish law on this question in the Be'er HaGolah, and then he goes some more. That's a super commentary on the Shulchan Aruch, the Be'er HaGolah. This is testimony being given in a court of law. He's talking about the super commentaries of Shulchan Aruch. And then he says, and it's funny that it says Turei Sahag. This is the Taz, Turei Zahav, which is transliterated improperly here. So he's quoting authorities about why he should be correct. And then he tells you, as a matter of fact, which I think is interesting, this testimony was put in doubt by the referee, which I kind of felt for the synagogue, and I felt for Reverend Mendes as a result. I officiated, this is testimony, I officiated as the minister at the funeral of Adela Cohen, who was interred on or about March 2nd, 1890. The forms of worship at her funeral were absolutely those of the Orthodox Jewish faith. The interment of Adela Cohen in the row of the defendant's congregation was an unconditional interment. This is the regular burial, no intention, nothing to do more. And in his testimony, he says, which is our custom today, when there is a conditional burial, we say, Hakivura hazot hi al tenai. This burial is conditional, without any specific anything. And I'll tell you, at the very end, I'll tell you about our customs today at burial. So that's Mendes. Bernard Drachman. And I just gave you little pieces. These things are really interesting, and anyone who's interested in this, these figures, they give you this is their testimony. They're telling you about their biographies. It's quite interesting. Bernard Drachman. Since 1890, I've been the rabbi of Zichron Ephraim. Zichron Ephraim today is Park East Synagogue. I'm a graduate of Columbia. He was born in New York, by the way. And also the University of Heidelberg with a PhD. I'm also a rabbi of the Breslau Seminary and have rabbinical certificates. He gives you all his bona fides. And he's on the faculty of JTS. And then he says, I'm familiar with Jewish law relating to burial and disinterment, and I've considered these questions particularly. And then he gets asked if, in his opinion, was this a temporary burial or not? And he says, you can't go by what might have been in the mind of the husband. It's only what they say. If somebody intended that they wanted to move it, they should say it. That's the only thing the congregation can go by. Meaning, if the family didn't say we want to move her later to a family plot, Shearith Israel doesn't know it, that's an unconditional burial. He's coming on the side of Shearith Israel. We'll get to the comments later. Okay. Louis Ginsburg. I keep moving this. I don't know if you can see it, but there's like a little toolbar that I have to keep moving in order to read what's on the screen. This is from the testimony of Louis Ginsburg. Now, who is Louis Ginsburg? Louis Ginsburg was the most brilliant and important Talmudist and halachist of JTS in the first half of the 20th century. And he was a Lithuanian-trained rabbi from famous yeshivot. I forget which ones, maybe Kovno or something like that. And he's from a rabbinic family, and all the poskim in the Orthodox world know him, and he knows them, and he's related to them. They've studied in yeshiva together. And so even though he's at JTS in this time of transition, he is a respected scholar even in the Orthodox world, even if they don't like him. And by the way, just as a complete aside, anyone today in the Orthodox world who makes kiddush on grape juice as opposed to wine and makes the bracha borei peri hagefen is relying on a responsum written by Louis Ginsburg, just as total aside. Anyway, he says, I want to be understood that rabbinical law, halakha, does not speak about intentions, but about conditions. A disinterment is only allowed when the burial of the dead is conditional, meaning al tanai. They have to say it. At the moment of putting the corpse into the grave, the condition has to be expressed. This is not my own explanation, but it's a decision of well-known cases, and he cites them. Saying as a matter of halakha, it can't just be, oh, I'm in my mind that we're going to do something later on. And now we have Solomon Schechter, who I don't think I really need to say much about, but Solomon Schechter was a giant of academics. He was a scholar, a Geniza scholar, a rabbinic scholar. He's brilliant if you read what he's written, especially, I don't know. I don't even know. I couldn't even go on enough, but he comes to New York, take over JTS from the presidency of JTS from Henry Paramendes. And it's under his guidance, not only because of him, but lots of factors, but during his reign, and probably because of his own personality, that conservative Judaism starts to separate from Orthodoxy, and a rift divides the Orthodox world and the JTS and what becomes the conservative movement. That all starts during his era. So this is his testimony in this case. If a person died and the family, this is the question that was asked him. If a person died, the family intended to bury him temporarily, meaning al tanai, to move the person later. But didn't say anything about it at the time of burial. Would it be proper for the congregation to take that as evidence that there was a tanai, a condition at the time of burial? And he says, I should think that the condition must be made. If I make a condition, I make it in the presence of the people who are interested in it. It is the expression of the case I quoted, where a rabbi died and the son said in the presence of the people there, I buried my father with the purpose that we'll move him later. You have to state it at the time of burial. Family didn't do that here. So he's taking the side of Shearith Israel. And the other ones are not going to read through. They're not that. They weren't deposed. There's no question. There's no back and forth questioning. But Moses Gaster and Herman Adler also. These are Moses Gaster is the chief rabbi of the Spanish Portuguese community in London. Herman Adler is the chief Ashkenazic rabbi, the chief rabbi of the British Empire. No slouch. These are big names and also big scholars. Gaster in particular is a big academic scholar as well as being a rabbi. And Herman Adler is a bit of posek. People refer questions to him, and he answers Halakhic questions. And so they're coming on the side of Shearith Israel also for the same reasons as given by others. Well, Joseph, even today, some secular courts have little respect for religious belief. That's because we try to avoid what the court did here. Courts do not want to decide religious law. They do everything they can not to, but that's not what happened in this case. And now we come to the other side, Kaufman Kohler. Who was Kaufman Kohler? Kaufman Kohler was a prominent Reform rabbi. He was president of Hebrew Union College. He was a rabbi, not of Temple Emmanuel, but some other Reform synagogues. He's one of the big editors of the Jewish Encyclopedia. Several people in this trial were editors of the Jewish Encyclopedia or contributors to the Jewish Encyclopedia. Funk and Wagnalls, this incredible work of scholarship. In fact, Kaufman Kohler writes an entry in the Jewish Encyclopedia around 1905 or so, called, and you can look it up, Disinterment, where he gives this case and states the opinions of those against him and him. He finishes with his own opinion, saying that it's permitted. But this case makes it into the Jewish Encyclopedia under the entry Disinterment, written by Kaufman Kohler, who was a witness in the case. And basically, he has a very interesting thing. He says, if it was the intent of the decedent, meaning this woman, Adele Cohen, that she wanted there to be a family plot and she wanted everyone to be buried together, then it's incumbent on the family to make that happen, even if after the fact. And so he says, not only is it permitted, it's required that they get a family plot, that they move her to it, and that everyone gets buried together. Now, one of the things that's brought up here and given very short shrift is that Shearith Israel, in an attempt to settle the case, offered them to move the father to the Shearith Israel cemetery, that they would make a family plot around where their mother was buried. Sure, it wasn't in the family section; it was in the regular row. But they could take the next grave was available, and they could make some of the nearby and make a family plot for them. But that was rejected, and the court seems to not give it any weight. But that would Shearith will try to settle it, but it didn't go anywhere. One of the interesting things in Kaufman Kohler's testimony is he's asked, aren't you a Reform rabbi? What about this is an Orthodox congregation? He says, in the opinion I have expressed today in regard to this interment, I do not speak as a Reform rabbi, but as a rabbi who knows the law. Quite interesting. And here's what I think is the most interesting. This was a witness for the plaintiff, who is the brother of the rabbi of Shearith, Israel, the defendant. And I just want to read what his biography is interesting. Also, little things you can sort of get out of his testimony. He says, for 30 years, I've been minister of the congregation Shari Tefillah in New York. That's a Reform congregation. I have made a study of Mosaic law and of the rabbinical law in London under private instructors. I have smicha privately, and at the Breslau Theological Seminary. I received the PhD at the University of Jena. I am a brother of Henry Paramendes. His degrees are MD. He's a medical doctor. He is not a PhD. And a DD, he's a doctor of divinity from JTS. He has no degree of PhD. This is fascinating to me. He's basically saying, I know more than my brother. And then he has this really interesting paragraph. I do not belong to the ultra-Orthodox Jews, but to the moderate Reform Jews. We observe the dietary laws and principles with the and many principles which the extreme Reform cast aside, meaning he observes traditional laws. The extreme Orthodox are apt to interpret the laws in the most puritanical sense, which moderate conservative Jews would not follow. This is before there is something really called conservative Judaism. He's using that term, which is interesting. For instance, both conservative and Orthodox would consider it wrong to erect a tent on Shabbat because it is work, melacha. The extreme Orthodox would apply that principle to prohibit opening an umbrella, the same as erecting a tent and carrying a burden on the Sabbath day. Well, he doesn't say it, but he's saying that you can. I think you can put an umbrella. It's not the same as erecting a tent, and that's the difference between conservative camp and Orthodox camp. Now, this is 1902. This is very early for this language and these distinctions to be being made, and here they are, and they're from people that we know. Frederick de Solamendes, the brother of Henry Paramendes. Anyway, his opinion is that the essence to conditionality, if it's going to be al tanai, is intent. It's not a matter if they said at the burial, this is a conditional burial. It has to be the mind of the family or the minister, I guess, of the family, that there was going to be a movement. And if the minister at the funeral was under a misapprehension on his part as to the family's desire, if his brother, Henry Paramendes, didn't know that the family wanted to move the mother to a family plot, the burial would, that intent, let's see, as that intent was, the burial would not be conditional. Hold on, I think he means it the other way around. Well, it's a little unclear from here, but basically he says just the fact that they didn't tell the minister, they didn't tell my brother that they wanted to move their mother does not mean that burial was final. They had the intent to move her. They didn't have to say anything. The fact that they thought it is enough to make it a conditional burial. That's his opinion. And now we get to the most interesting. J.D. Eisenstein. Okay. So J.D. Eisenstein, Yehuda David, I think it is, he was, I think he was born in Russia. He moves to New York pretty early. He's here like in the 1870s already. And he's like an autodidact scholar. He has a business publishing things. He publishes Jewish works, newspapers, and Hebrew things. But he is very, very strictly Orthodox. In fact, he goes to Beis Medrash Gavoa on Norfolk Street in the Lower East Side of Manhattan. That's the main Russian Orthodox, severely Orthodox shul. Later on, that would be where Jacob Joseph and the Kehillah movement is centered around Yeah, so he's strictly Orthodox person. In fact, he's interesting because he is academically minded, and so he writes a lot, apologetics, defending traditional views from biblical criticism and things like that. And he's very prolific. And he writes a lot of the articles in the Jewish Encyclopedia. So we have, if you want to know, Louis Ginsburg writes a lot of articles in the Jewish Encyclopedia. Kaufman Kohler writes a lot of articles in the Jewish Encyclopedia. J.D. Eisenstein writes a lot of articles, and some of the others also, including Henry Parmenides and Frederick de Tolmendes. All these people are involved in the Jewish Encyclopedia, and they're here in this case on different sides. So he gives the Reform rabbis, including Frederick de Tolmendes, they give weak answers to what the Orthodox are saying. And here is an Orthodox rabbi who interprets even against Herman Adler, Glaster, all these Schechter, he interprets it differently. Permission to disinter betoch shalo is from the original source Machot. The exceptions allowing disinterment in order to remove to the Holy Land and when it's damaged, those are all new and inferred and not in the original text. They're saying what's in the Shulchan Aruch is only a portion of what's original. The original thing has to do with this term betoch shalo. So he thinks that's primary. And then he says, this whole thing about al Tanai comes from the Talmud, and the word Tanai is not in the Talmud, and he has his own things about how he ranks what's important in this case. And then he says, if the disinterment is permitted, if betoch shalo, meaning to a place where it is his, where there are lying members of his family, and he says specifically, the Hebrew is b'nei mishpachto. Mishpachto includes all members of the family, whether near or far relatives and children. It would constitute, so he's saying that doesn't matter that the family plot came later, doesn't matter that Miss Adela was buried and the family plot was purchased later. That doesn't matter. When it says that you could move someone betoch shalo, it means you could move them to their family plot even if that wasn't extant when they were buried. All the other rabbis don't say that. He's the only one. And then he says, for it to be a conditional al manat, it would not be necessary for the minister to say anything at the time of burial. The only thing he has to do is the intention, like Frederick de Tolmendes. Now this reminds me, if you're still with me, if you haven't gone to sleep yet, of the famous Halakhic question about whether mitzvot tzricha kavana. Is it enough to do the mitzvah, or do you have to intend the mitzvah? This is something similar having to do with conditions. If you just have the intention, or do you have to say the words, this is a conditional burial? He's coming out on the side that the intention is what matters. And then they ask him in the course of the litigation, they ask him in his testimony, do you consider yourself qualified to express opinions on Jewish law? Because they ask him, the question I didn't put you here is, are you a rabbi? He says, no, I'm not a rabbi, I'm just learned. I've learned for many years. He says, do you consider qualified to express opinions? He says, I do to a certain extent, but at the same time, I generally ask the opinion of some rabbis. And this, are you expressing today your own conclusion or the opinion of others? He says, my own opinion, which was approved by others. That's what his answer is. So who was the other or others? And that he answers on the next page here. One of the rabbis whom I consulted before giving my opinion was Rabbi Ridvas, who has written 2 commentaries on the Jerusalem Talmud, which are considered the greatest works of the last century and accepted by all students. So who is Rabbi Ridvas? His name was Yaakov David Vilovsky, and he was the Rosh Yeshiva of Slutsk Yeshiva. If you're in Yeshiva world, that means something. Most of us doesn't mean anything. And he started a commentary on Talmud Yerushalmi, and then he ran out of money to publish it, so he came to America in 1900, where he was able to get subscribers for it to complete his commentaries. And then he goes back, and then he comes back to America in 1903. This case is happening all in this period of time. When he comes back to America in 1903, he drops his original name and he takes the assumed name Ridvaz. And if you're wondering, if you've been in yeshiva and you're wondering who this is the Tosfos Rid. It's one of the commentaries when somebody who learns the Yerushalmi, the Talmud Yerushalmi, they know the Tosfos Yid. Ridvaz. Now he was elected to be the chief rabbi or the head rabbi, the most senior rabbi, what they call in this article, the United Orthodox Rabbis of America, which is the Agudas HaRabbanim. This is super ultra Orthodox right wing. Today they still exist. They're like the right wing yeshivot and the Hasidim all together, and they are, well to the right, way to the right of YU and what we would call centrist orthodoxy, or for lack of better terminology, they are the Agudas HaRabbanim. So he is very right-wing. And what is incredible, if you can take what J.D. Eisenstein says, that he went to him with this question and he answered this question this way, what it means is that the head of the Agudas HaRabbanim, the most right-wing, is aligned in this case with the Reform rabbis. And ultimately, the court says that this interpretation is the correct halakha. And so that's my presentation to you. I don't know where this leaves us off, but this is a little small piece of Shearith Israel history that is crazy. Courts would never write decisions like this today at all. They would not touch. In fact, we had pretty important court case recently with regarding the Rimonim, and in the end, the appellate court said, we're not going to touch Jewish law. Don't touch Jewish law. We're going to use neutral, things that lawyers can talk about. And that's how we're going to decide the case. But not in that case in 1905, 1906, where they actually find, as a matter of fact, that the halakha is according to the Cohens, that they can disinter. Hope you enjoyed. Let me allow you to all unmute. Okay. Any insight? Yes, Roger.
In 1949, the body of Herzl was moved from Vienna to Israel. He was in a family plot. So,
well, one of the exceptions, I didn't talk about it here because it wasn't in this case. But one of the exceptions is to move to Israel. You can always.
No, you mentioned that and it was listed. But it's interesting because you have a conflict between the family plot, which is betoch shelo, and then you have the move to the Holy Land, which is also an exception.
Right.
So you have an interesting conflict between the two. I was wondering whether anyone knows whether the issue was then decided and what was the reasoning for it. I never thought about this as a problem.
No, we can research that for part 2.
Of course, if it's Herzl, is Israel betocho?
Yeah.
No, clearly so, but betocho is also his family.
Sure.
Yeah,
right.
So that, and they were in Vienna. That's why I was asking.
Of course.
And by the way, the Ginsburg that you mentioned, his book about the history of the what's it called? Legends of the Jews.
Yeah,
very beautiful. Yeah, it's very beautiful.
Yeah,
his son was one of my teachers a long time ago.
Absolutely fascinating story.
Yeah, who knew?
And it's absolutely true that no court would do that today. I've been involved in cases where even we were trying to push the court a little bit to consider that they absolutely wouldn't touch it. And I can tell you, Michael Helfand, who's a very good guy and a friend, is somebody who is pressing in the law review literature for the courts to do a little bit more, to not be so abstentionist and to be willing to consider.
Yeah, so in that article, which I didn't tell you about too much, I'm going to stop the recording here so I can say things freely.